Thank you guys so much for having me today. I'm excited to come and speak to you. I'm going to be talking about elder law and estate planning. My name is Chasity Stratton. I am one of the managing partners of Stratton and Reynolds. Well, when I talk about estate planning and as we get older, I find that most clients have multiple concerns, but most of them will fall into 5 major categories. All right. Number one is obviously to pass their hard-earned wealth on without government or court interference. I'm going to talk about in a few minutes what probate is, but that becomes an important part of this because when we pass away, how do our assets get into the names of our beneficiaries or heirs? Well, oftentimes that's through a probate process, and that is not the most fun process in the world if you've never been through it before. 2 is, of course, to avoid unnecessary taxes and fees. Now, for those of you that are joining us online from other states, obviously this is going to be a South Carolina specific thing, but does anybody know how much probate costs? Has anybody had to probate an estate recently in here? So a couple of years ago, they actually increased the fees in South Carolina. So it's about $1,000 per $100,000. So if you've got a house that's worth $400,000, you've got $4,000 in court fees alone, not including what you're paying for an attorney to maybe help you through that process or to help your loved ones through that process. So it's expensive. Also, of course, taxes. Most of us want to pay as little in tax as we have to, right? We want to do our fair share, but we don't pay more than what we have to. So we want to talk about how to avoid that. This is a big one. How do we avoid going broke from nursing home costs? Does anybody know what the average cost of a nursing home is in South Carolina? Yes, ma'am. It is right around there. So Medicaid, when we'll talk about Medicaid, I promise I'm going to get to that. Medicaid says it's about $6,500 a month, but I don't know where they get that number from because here in the Columbia and Lexington area, you're right. It's going to run somewhere between $8,500 and $10,000 a month. I don't care how much money you have saved. If you're writing a check for that every month, that's going to deplete funds really quickly. All right. This is a big one. How do we protect our family from creditors and predators after death? I have a brother. I talk about him in these proceedings fairly often. He's a wonderful guy. I was telling somebody a few minutes ago, he's a pharmacist. He's a smart guy. But he is socially awkward, is probably the best way I can describe it. And he has been taken advantage of by multiple people before online. He'll meet a lady online, send her money, she's gonna come visit, she doesn't show up. Imagine if somebody like that, you pass away and you leave them $300,000. What happens? Do they end up giving it to the wrong people? Does Uncle Joe, who just found out you inherited $300,000, call and try to ask for money? What if you have a loved one who has credit problems? Maybe they have tax liens or they have medical debt. Right now, 75% of bankruptcies in the United States are caused by medical debt. So if you have a child or a loved one with health issues and you leave money to them outright, guess what? That money is going to go directly to pay those creditors. So how do we protect them from that happening? And then, of course, families fighting over money. This is the one that obviously touches my heart the most, and I hate to see it. When people are fighting in a state, sometimes the probate court will actually call us and say, hey, listen, we got family members here fighting. They can't agree on things. Will you step in and be the executor of the estate? Which I don't mind doing. So we say yes. And so we'll do that. One of the saddest estates I've ever been involved in was actually 2 brothers. Mom had died. She had a piece of property on the lake. It was an old house. The house was nothing special. Actually, I'm certain the people who bought it bulldozed it, but it was her home and the kids had grown up in that home and they were fighting over who was going to sell it versus keep it and fighting over the money and all of that. So I go to the house and I've got to meet with the realtor because it has to be sold. And I walk into the house and you come in through the garage and you walk into the kitchen and right there's an arch that leads into the dining room. And on that arch are notches with her kids' heights as they grew up. These are 2 boys that will never speak to each other again because of money. And at the end of the day, it was because one of them lived with mom and thought he was getting the lake house. The other one lived in Florida. He just wanted the money. and mom didn't plan effectively. She didn't plan at all. And so what ended up happening was they had to sell the house and the one guy lost his home. If she had made appropriate estate planning decisions, that would have never happened. And maybe those brothers would still have a brotherly relationship today. But lack of planning causes family fights every time. So how do we avoid that? So again, I'm not going to ask for a show of hands, but how many of us can look at this list and say, yeah, I'm concerned about at least one of those things? Almost all of us, right? So that's what we're going to talk about. Before we get there, again, I want to introduce myself. Like I said, my name is Chasity Stratton. I am one of the managing partners at Stratton and Reynolds. I went to the University of South Carolina for undergrad and for law school. So if you went to the school in the upstate, it's okay, I'll forgive you, but I do love my Gamecocks. So this is my family. When people ask me my why, this is my why. The handsome guy over here is my husband. He is not a lawyer. He is not my business partner. And I'm appreciative of that because he gives me a unique perspective sometimes on things. And then this adorable little thing down here is my daughter, who actually this says she's 7, but she just turned 8. I haven't updated my slides yet. I am not so by myself. I have a great team. So at Stratton and Reynolds, we have absolutely wonderful people that work with us. I like to introduce them in this only because if we end up doing work with you or your family, you're not just going to work with me. Yes, you will work with me primarily, but I'm, again, not an island to myself. So over here in this picture, we have got Madeline first. She is our probate paralegal. She is wonderful. The lady with the red hair who's kind of in the front next to me is Diane. She is our receptionist and she is superwoman. The guy in the back behind her with the beard is Jeff. He is one of our attorneys. Next to him is Amy. She does our real estate. Then the guy in the back behind Amy is TC Reynolds. He is the other managing partner of Stratton and Reynolds. And then this lady on the end is Liz, and she's our head paralegal. She's actually been with us for over 8 years. So getting back into this, why do we not do our appropriate estate planning? What's the reason? The number one reason is procrastination, right? We think we have more time. For some of you in this room or who are attending online, you guys are caregivers. Maybe your loved one is already to the point that they can't do their documents, right? They might be at a point where capacity-wise, that's not an option anymore. We're going to talk about options for that circumstance, but don't be that person. All of us think we've got plenty of time to get this done, but at the end of the day, none of us have a crystal ball, right? So get your planning done. The second reason, and what I think is probably the more important reason, is lack of knowledge. You don't know what you don't know. So I'll give you an example of that. Again, this is South Carolina specific. So for those of you that are in other states, just bear with me here for a second. In South Carolina, we do something weird with real estate. In most states, if you own real estate jointly with your spouse, so for like me and my husband, if we own our real estate and it says Chasity and Nick Stratton, if I die, it automatically goes to my husband. But South Carolina does not do that. We default to something called tenants in common, which means if it says Chasity and Nick Stratton, we're each apportioned to 50% ownership in that property. So if I die, my 50% has to go through probate to get into my husband's name. Most people assume it's automatic. So they think, oh, well, I own everything jointly with my spouse. So I don't need to worry about wills and trusts and all that. It's going to go to them anyway. That's not the way the law works here. To add a different level of complication to that, if you don't have a will, the state of South Carolina has one for you. It's called our intestacy code. Our intestacy code probably doesn't do what you think it does. So if you are married, our intestacy code says half goes to your spouse, half goes to your children. So where you get really nasty situations is when you have blended families. Although sometimes even bloodline families can be nasty, but oftentimes it's blended family situations. I had a case that I was working on a couple of years ago. This lady came to see me. She had actually gotten married. It was a second marriage for her and for this gentleman. They were in their mid-40s. At the time that they got married, they both owned real estate, had a little bit of equity in both of them, but they both had mortgages, and they decided they didn't want to keep both and pay 2 mortgages. So she sold her house, took the equity that she had in her house and used it to help pay down his mortgage and moved in with her husband. Most of us would say, good decisions, right? Well, about a year later, her husband died in a car accident on the way to work. It was a single car accident. He hit a tree. I actually think he had a heart attack is what the coroner ended up saying, and then hit the tree, but he was dead upon impact. So she now doesn't know what to do. She has a spouse. He just passed away. He didn't have a will. Well, what did I just say about people that don't have a will? Half goes to surviving spouse, half goes to surviving children. Well, he in fact had a surviving child, a 19-year-old son who was in prison for drugs. And guess who was getting out of prison? The 19-year-old son, who just inherited half the house that his stepmom's living in. Where's he going to go live? In the house, right? She can't kick him out. He owns half of it just as much as she does. So she ended up walking away from it. She ended up losing about $150,000 because of what she used to pay down this gentleman's mortgage. Proper planning could have kept that from happening, but they didn't know. They had no idea that that's what the law would do. She had no clue that this stepson she had never even met, because he had been in jail since their relationship started, was going to come in and cause these problems. That's what we talk about when we say you don't know what you don't know. So why do most estate plans fail? Number one, poor documents. All right. I always tell clients, if your documents talk about guardians for your minor kids in the 1970s or 80s, and your kids are all now adults, it's time to update your estate plan. 100%. Your documents need to be looked at or updated every 3 to 5 years. That's for you, that's for people you may be caring for. That's how often either laws change or life circumstances change. Think about yourselves. Look at your own life. 5 years ago, did your life look exactly the same way it does today? Some of us, the answer may be yes. Some of us, the answer may be no. No nursing home protection. One of the things, and we're going to talk about this in more detail in a minute, one of the hardest things with estate plans is for married couples. If you have a will and you're married, almost all likelihood, your will is what I call a sweetheart will. It leaves everything to my spouse. And if my spouse has predeceased me, to my kids, right? For those of you that have wills in the room, if you're married, I'd put money on the fact that that's probably pretty close to what it says. The problem with that is, if you're talking about nursing home costs and you leave everything outright to your spouse, we're gonna talk about Medicaid in a few minutes, guess what? Your spouse has to spend that down to $2,000. So everything that both of you worked hard to accumulate, you've dumped on them to make that a harder problem. There are ways you can structure leaving assets to your spouse to take care of them without disqualifying them for benefits. But it has to be done the right way, and nobody talks about these things. For people that have a trust, not funding it. We see a lot of people, and I'm gonna talk about what trusts are and all of that in a few minutes, but we'll have people that come here, especially from Florida, maybe they went down there to retire and now they're sick and they've moved back up here to be close to kids, and they'll bring in and they'll say, oh, I did this trust. And they have this beautiful binder. And I ask them, what's in the trust? And I get complete blank stares. They have no idea. That's because it was never funded. You have to actually put assets into a trust for a trust to work. All right, and then we'll explain that again in more detail. No timely updates, I've already talked about that. No remarriage protection. The average woman lives 14 years after her spouse dies. Okay, but if the female dies first, the male survives. If they are under the age of 80, there's a 70% chance they will get remarried. Women, we're not that different. There's actually a 57% chance that we will get remarried. So my question always is, do you want the assets that you and your spouse have accumulated together to go to the new wife, new husband, new boyfriend, new girlfriend? Most of us would say no, but unfortunately it happens every day. And sometimes it happens not because it's a conscious decision, but because somebody is taking advantage of another person. My business partner's family actually lived through this. So grandma was primary caregiver for grandpa. She died very suddenly and unexpectedly. So grandpa was still alive. He needed help after his wife died because, again, she was primary caregiver for him. So the family hired a 37-year-old caregiver to come into the house and help care for him a couple days a week, multiple hours a day. About 4 weeks later, he married the 37-year-old caregiver. Was he completely competent to do that? Well, that's the question, right? Capacity is sometimes a gray area. He was competent enough that the court upheld it and upheld him updating his documents. But obviously, if you think about it, and certainly what my business partner's family has always held, is that no, he wasn't fully competent to do that. And that would have never been what grandma wanted. She had multiple children, she had grandchildren, none of them received anything. It all went to the 37-year-old caregiver. That's the kind of stuff that becomes important when we talk about your documents. So the easiest way for me to explain this is to give you a real life example. So this is Bill and Mary Jones. We're going to talk about them in a few minutes and about their estate. Their estate is worth a total of about $1.4 million. Now, a lot of us will say, oh, my estate doesn't look like that. And it might not. But for a lot of us, if you add the value of your real estate, your IRAs or 401ks, your life insurance, we get close to that number more often than we think, okay? They have kids, like a lot of us in this room. They have 2. You can tell just by looking at it that John is a winner. He has everything that you probably could assume just from the picture. And then Susan, but she's not perfect either. Like most parents, they love their kids. They want to make sure their kids are taken care of. So what are their planning options? They have the same planning options that every person in this room has. Number 1 is my favorite one. It is to spend every dollar, right? Spend it all. If you have a crystal ball and know when you're going to die, this is by far the best option, because your loved ones will not appreciate your money the way that you have worked hard for it, okay? But what's the obvious issue here? We don't know when we're going to die, right? We have no idea. So what if you spend it all too quickly, right? I have a lady that just passed away this year, one of my clients, she's 106. So if she looked at her family and said, oh, well, usually people die in their 90s. I'm going to plan to live to be 90. But she lived to be 106. She spent her money too fast, right? Or what happens if you go, everybody in my family lives to be in their 90s, but I die on the way to work in my 40s? Happens. So it's not a good planning option. Die intestate. I've already talked about that. You don't want to do that. You want to make sure you've got a will in place that says, at a minimum, you have a will in place that says what you want to do. Put everything in joint tenancy. If you don't hear much else that I say today, please listen to this, okay? Do not put your kids or other loved ones on your accounts. You can put them on there as power of attorney. We're going to talk about what a power of attorney is. But as soon as you put people on your accounts, you are putting them on there as joint owners. And joint ownership opens your assets up to the liability of that person. And then, of course, people tell me, oh, Chasity, my kids are perfect. We're not worried about liability. Let's use that as an example. Let's say they are, in fact, the most wonderful, perfect people in the world, right? We're not worried about their liability. What happens if they get in a car accident and kill somebody? It's an accident, right? It's not on purpose. Something happened. What happens if the damages are above their liability limit? Guess what? They can look at your account. They can look at your property, your assets. You have to be very careful. That's why powers of attorney are so important. We're going to talk about what those can do. But joint ownership is a scary thing if you don't want your assets to be liable. Create a simple will. A will, and we're going to go through this in a few more minutes with Bill and Mary Jones, is just instructions to the probate court on how probate assets get distributed. That is it. It is not automatic. It doesn't avoid probate. It's just instructions to the probate court. Create a trust, we'll talk about that, or create a complete family estate plan. So back to Bill and Mary Jones, they have a to-do list. Their to-do list looks a lot like what a lot of our to-do lists probably look like. They want to exercise, they want to plan vacations, they're going to retire soon, and they want to create a will. So they go see Frank in their church. Frank sings in the choir with Bill. He's a good guy. Frank's a lawyer. Frank's a family court lawyer. Anybody know what family court lawyers do? Divorce, that's right. Divorce, child custody, adoption, that kind of stuff. Frank says, yeah, I do simple wills for people. That's fine, come see me. And he does a will for Bill and Mary Jones. And he does a will that looks just like the will I was just talking about. Leaves everything to each other and then down to the 2 kids. Check, they have something done on their to-do list, right? So then life goes on. Another about 6 months to a year happens, and then Bill has a stroke, has a pretty major stroke, ends up paralyzed on one side. He's disabled. So the first question that they have to say is, how do they pay for long-term care expenses? First are, what are those expenses? Well, number one can be in-home care. Obviously, that's the one we all want, right? We want to stay in our homes as long as possible. Statistically, people live longer and do better when they're at home getting care at home. The problem with that is in-home care is even more expensive than nursing homes that cost $10,000 a month. You think about your average nurse. If you have non-nursing personnel, you're looking at $15 to $22 an hour right now. If you need that 24 hours a day, do the math on that. It's pretty expensive. But what if you actually need a nurse to come in and do things? You're at $27 to $45 an hour. $20,000 plus a month, every month. That's hard for anybody to be able to pay for a long period of time. There is adult daycare that exists. Those are perfectly fine options, but just like with kids daycare, they're only usually during business hours, Monday through Friday. Assisted living. It's very important to know the difference between assisted living and skilled nursing care, because when we start talking about things like Medicaid, Medicaid does not cover assisted living. And assisted living facilities, and I don't think they're trying to do this because they're trying to be funny. It's just because it sounds better to say Lakeside Place or whatever it may be. They don't normally say assisted living in the title, right? They'll say memory care, or they will say senior living, or whatever it may be. If it does not look like a hospital, it's probably not a nursing home, okay? Assisted living facilities look like apartments. Sometimes they're shared spaces, but really and truly, they're there to assist with things. They make the food, they may help with dressing or changing clothes, but for the most part, the person is either able to ambulate or is a one-person assist, meaning they can move into a wheelchair. Skilled nursing or nursing homes are going to need around-the-clock nursing care. Okay, it feels very much like a hospital. It's important to know the difference because when you talk about Medicaid, Medicaid does not cover assisted living. So there's only 5 ways to pay for long-term care expenses. First way is pay out of pocket. Spend your money until you're broke. Spend every dime of it, right? Perfectly okay thing to do, but most of us, if we work really hard for our assets, might not be what is ideal for us. Buy long-term care insurance. For those of you that are young enough in the room or that don't have pre-existing medical issues, I don't sell it, but if you can get it, by all means get it. It helps, especially if you want to try to stay at home, because a lot of them will pay for things at home. But for a lot of our loved ones, by the time we're looking at this, they already have conditions that are going to make them ineligible, right? So long-term care isn't even a possibility of getting insurance for that. Medicare. Medicare does not cover long-term care, period. It does not. It covers up to 100 days in a skilled nursing facility for rehab after a qualifying hospital stay. So when Bill had the stroke, and once he was in the hospital for at least 3 days, he could then be discharged to a nursing home and could be there for rehab. But it's really important, you have to be actively participating in rehab. Because if you're not, it's Medicare fraud for them to keep you there on Medicare. So they'll roll you off. For those of you that are in this room that are caregivers, if you've had a loved one there, there's sometimes they only get there 20 days, they only get 40 days, because either they've reached the point where they have maxed out on what they can do, or they're not actively participating in rehab. I mean, think about Bill, if he's paralyzed on one side, if they want him to do those exercises and he cannot do them, they can't keep him there on Medicare. And again, it's only 100 days, so you're looking at a little over 3 months. Doesn't cover all of it. And this is one of those things that thankfully more people are talking about it, but especially when I started doing this over 10 years ago, clients would be shocked when I would tell them that Medicare won't cover their long-term care. They thought, well, we voted in Social Security and Medicare because it's supposed to take care of us when we're older. I don't understand what you're saying, Chasity, but at the end of the day, that was not what this program was ever designed to do. Medicaid. So I'm gonna park here for a minute because I know that there are a lot of questions about Medicaid. And I'll tell you, I could do an entire 2-hour seminar just on Medicaid. So I'm not gonna get real deep down into it. Obviously, if you have specific questions about that, ask them at the end, or we can schedule a time to sit down and talk. But Medicaid is a federal program that is administered by the states. The reason that is important is the states have to comply with some overarching federal law, but they get to decide what their program looks like. And so the rules for it are very, very state specific. So if you like Google, which I like Google, just keep in mind that even with Google, you have to be looking at stuff if you live in South Carolina or your loved one does, that's South Carolina specific. If you live in Georgia or California or wherever it may be, it's important that whatever you're looking at is state specific. Here in South Carolina, a person who wants to go onto Medicaid to pay for long-term care cannot have more than $2,000 in countable resources in their name. What are countable resources? Well, that term is very important. There are some exempt resources and there are countable resources. Your first exempt resource is a house, so long as the equitable value is under $543,000. Now, people stop me there and say, wait a minute, Chastity, my friend had to sell their mom's house because she was on Medicaid. That is because it is an exempt resource for qualifying. But when a person dies, Medicaid then makes a claim against their state for something called a state recovery, and they want to be paid back. So that's where people have to sell the house, is through the estate recovery process. So one of the things that's really important is to try to keep real estate out of probate, because if you keep it out of probate, you can protect it from estate recovery. So we'll talk about that. Well, when I say real estate, I mean primary residence, okay? But we'll talk about that in more detail in a few minutes. The second thing that is exempt is one vehicle. But if you're a married couple and you own two vehicles, it doesn't matter, only one is exempt. The third thing is if there is a community spouse at home. So if one person's going to the facility, but there is a well spouse who is at home, the well spouse's tax deferred accounts like IRAs or 401ks are exempt. This actually can be really helpful if, let's say, the spouse who's at home has $500,000-$600,000 in tax deferred accounts, but their spouse does not have very much. It's possible a person even with those kind of assets can still access Medicaid. So the rules, it's not that you have to be completely destitute to be on Medicaid, it's that you've got to comply with the rules. The other thing that the community spouse is allowed is an additional $66,480 of just other. That could be cash in the account, that could be stocks, that could be an extra vehicle, whatever it may be. You're allowed life insurance with cash value under $10,000, and you're allowed pre-need funeral arrangements. Outside of that, just about everything else is countable, because at the end of the day, cash is king, right? You can pay for it or use it to pay for your facility, it's countable. And a lot of people think, oh, well, it's all in my spouse's name. Understand, for a married couple, there is the exemption of $66,480, and there is the exemption of the IRAs and 401ks. But otherwise, if it's just sitting in a money market account in your spouse's name, it's still countable. Doesn't matter, because you're a married couple, your assets are there to take care of both of you. So the point of that is there are really specific income and asset rules when it comes to Medicaid. I am not meaning today for you guys to memorize all of that. What I want you to know is that if that's something that you are concerned about, your estate plan has to reflect that, right? You've got to make sure that you are setting things up in a way that those assets become attainable, or those benefits become attainable without spending down all of your assets. And there are ways to do that. Some of them are more complicated than others, but I can promise you the earlier you get that planning done, the better off you are, because Medicaid has a 5-year look back period. So if you want to transfer things into a trust, for example, to protect things for Medicaid, you got to do it 5 years before you need Medicaid. Otherwise, it's too late. There's crisis planning that can be done in those situations. That stuff is not easy to do. So Medicaid does exist. The other thing is aid and attendance for the VA. This will never cover all of long-term care costs. For a veteran, it's a little over $2,000 a month that it could help pay towards assisted living or long-term care. For a widow of a veteran, it's about $1,300 a month. But those benefits do exist. Again, they are income and asset based. So we've talked about these benefits that exist. Because they didn't do any pre-planning for Bill, unfortunately, locking back into Bill and Mary, they're just paying privately. The problem with paying privately is that the majority of their assets, of their 1.4 million, about 900,000 of it is tied up in Bill's IRAs and 401ks. Mary, like many of us in the room, was a stay-at-home mom. She raised the kids, she worked very hard, but Bill was the one who was putting money into the retirement. What's the thing about an IRA or 401k? Tell me what an IRA means. What do those words mean? Anybody know? Individual retirement account. Guess what? Individual means it's just in Bill's name. So if Mary needs to pull money out of that to pay for his care, how does she do that? Power of attorney. That's a great answer. The problem is they went to Frank, right? Frank's a good guy, but he did wills. He didn't do powers of attorney. So she has no legal ability to pull money out of that account. So they have to go to the probate court and ask for permission because Bill's not competent to do a power of attorney at this point. The capacity required to do a power of attorney in South Carolina is the capacity required to sign a contract. So I tell people, think of putting a roof on your house, right? You're gonna put a roof on your house. What do you have to know? You're gonna sign a contract with a roofing company. You have to know I need a roof, right? Cost, yes. You have to know who's gonna be doing it. Maybe what kind of materials. Is it gonna be a metal roof? Is it gonna be shingle? What's it gonna be? Power of attorney is the same way. You have to know I need a power of attorney. This is who I want to serve. This is the abilities or powers that I'm giving them. If a person cannot verbalize that, they are not competent to sign a power of attorney. So at this point, Bill was not. So they had to go file for what we call living probate, which in South Carolina is called a guardianship and conservatorship. Guardianship is about making healthcare and placement decisions. Conservatorship is about making monetary decisions. The average cost of a guardianship and conservatorship, if it's uncontested, is going to be somewhere around $5,000 in South Carolina, give or take, depending on what's going on there. For a contested one, it can be $20,000, $30,000 or more. It's very much sometimes like fighting over custody of mom or dad or whatever it may be. So they do this. They go file for guardianship conservatorship. Mary does for her husband. Why do we want to avoid that? One, it's humiliating. Nobody really wants to have a court deem them incapacitated, right? That's not something that's a fun process. The other thing is the court's in control. Now I'm gonna stop here. I love our probate courts, especially the ones here in the Midlands. I do a lot of work with our probate courts and our judges. We have really great ones. But does anybody know what the requirement is to be a probate judge in South Carolina? You have to have a high school diploma and be over the age of 18. That's it. Yeah, wow, that's right. So again, in your big counties like Richland and Lexington and Horry and Greenville, we have great probate judges. A lot of them have practiced in this area. They know the law, they know what they're doing. But then you get to some rural counties and you have some problems because you've got people there who are making decisions that half the time are not experts in this area of law. They just got voted in for a position because they happen to say that they're of a particular political party that's popular in that area. There is a lady right now, if you're bored, you can go to the judicial website. There's a county, I won't tell you which one in the upstate, but her entire judicial profile is about the fact that her cats think they're human beings. She's a probate judge, and she's making decisions about people's lives. That should scare all of us a little bit, right? But at the end of the day, if you're in probate, a judge is making the decision about what's going on in your family, and you have no control over that. They're in control. The court is in control, not you. Whereas when you're doing a power of attorney, you are picking the people you want to be in charge. You're not leaving that up to a person whose cats think they're human beings. You're making those choices. It's time consuming. So an average guardianship and conservatorship can take about 6 months if it's uncontested. If it's contested, it can take years. And of course, it's expensive. I've already talked about the fact that they cost, anywhere from $5,000 to $30,000, $40,000, depending on how contested it is. Ultimately, they get guardianship. Bill lives for another 9 months, and then he passes away. Guess what? They're back in probate. Bill had a will. Chasity had a will. It should have just left everything to Mary. That's what you told me. Yes, but a will is not automatic. A will only is directions to the probate court on how probate assets get distributed. So what I mean by that is Bill's will says everything goes to Mary, but she has to go through the year-long probate process for that to happen. Why does probate take a year? Because of creditors. So there is an at least 8-month creditors period in South Carolina, generally takes about a year, in which creditors can come in and file claims against an estate. And of course, all of my clients tell me, oh, I'm not worried about that. I live debt-free. I don't have credit cards. I'm not worried about that. Most of your creditors against an estate are not credit cards. They are expenses of last illness. So it's hospital bills, ambulance bills, nursing home, Medicaid estate recovery. And none of us really get to know what that's going to look like, right? So if you can keep things out of probate, you can shield assets from those creditors. Once the creditor's period is over with, all the assets have been inventoried, then things can be distributed, but it takes a year, like I said. Why do you want to avoid it? Well, I already mentioned at the beginning of this that it's expensive. About $1,000 per $100,000 just in court fees, not including what you're paying for attorneys or other people involved. It's time consuming. I have people tell me, oh, I want to do a will and I'm going to put my son, he is a doctor, I'm going to put him as my executor. My first question is, how many hours a week does your son work? Because let me tell you, it's work to be involved in a probate estate. You've got anywhere from 17 to 40 plus documents that have to be filed during that year-long period. Does your son, who's the doctor, have time to do that? Maybe he does, maybe he doesn't, depends on what kind of doctor he is, right? It's open to the public. If you ever come to my office, one of my favorite books we have in our little waiting area is something that they actually gave us, I think, when we joined the chamber in Lexington, but it's a book with historical pictures in Lexington. One of the historical pictures in there is when the doctor who lived on Main Street died and his assets were being inventoried for the probate court. There was a line of people down Main Street in Lexington who wanted to go into the probate court to see what the good doctor owned. Now, I think we have better forms of entertainment today. Most of us aren't going to line up to find out what somebody who died owned. This picture was from the early 1900s. But my point of that is most probate court records are available online. So if you got that Uncle Joe in your family who maybe wants a little bit of money after his sister died, guess what? He can see exactly what she owned by logging onto the website. Richland County, pay a $25 fee. You can see anything in anybody's probate estate. That easy. So if you don't want everybody to know what you own, keep it out of probate. And then multiple probates. If you own assets in multiple jurisdictions, you have to have a probate estate in every jurisdiction. So for a lot of my clients here in South Carolina, we like our coast, right? So we'll have our house here, but then we might have, let's say, a vacation property or a timeshare in Horry County or elsewhere. Guess what? You got to do your probate here in Lexington or Richland and a probate in Horry or Beaufort or wherever you might be. Same thing if you own property in other states. So it's difficult. 3 big worries after Bill dies: spouse's remarriage. We talked about that, lawsuits and creditors, and of course his final expenses. At the end of the day, they get through probate. Mary has the whole estate, which funny enough still is about $1.4 million because the markets were doing well. So even though they were spending money, she still is okay. Again, as I already said, surviving female lives about 14 years. But Mary only lives for 10. Mary develops Alzheimer's. In that 10-year period, she is placed into a nursing home. She can't handle her own affairs. So we're right back here in probate again, right? The problem is this time for the guardianship and conservatorship, it's pretty easy for Mary because we have a priority list in South Carolina. She's a spouse. She's allowed to make decisions for her husband. But when your spouse is gone, it moves to that next level of priority, which is your kids. Who has highest priority out of these 2 kids to make decisions for their mom? Everybody says the oldest. In fact, they have equal priority, no difference in age whatsoever. So what ends up happening is if one of them wants to be appointed, they have to go into court and explain why their siblings should not be appointed. So what that turns into is a mudslinging contest in court, right? I mean, I've had clients that have gone into court and talked about, he hit me in the head with a shovel when I was 4. I mean, it's crazy the skeletons people will bring out of closets because they're trying to win. And at the end of the day, that's what this is. This is a custody battle for mom or dad or whoever it is. Now, we look at this picture, and most of us would go, okay, well, if I was a judge, I'm going to pick Susan, right? I mean, she looks to be the one who's got her life more together. But if you put John in a suit and you pull the hair back, they could probably come into court and be a decent looking fellow, right? It happens. And the court judge doesn't know anything about your family. They don't know that John actually has all of these lawsuits and such. They have no clue. They have to make a decision, and we don't want that to happen. Then ultimately, Mary passes away. They're back in court again. At the end of the day, the things that mom and dad should have been worried about in their estate plan: 1, kids get divorced. Anybody know what the rate of divorce is in South Carolina? We just went over 50%. Over half of all marriages end in divorce. So if your will is like Bill and Mary's, then you have a will that leaves everything to each other and then down to your kids. Your kid inherits and then they go through a divorce. Technically, inherited property is supposed to be protected in the divorce, unless it's been commingled. So guess what? In this circumstance, let's use Susan as an example. Susan inherits $700,000 from her mom and she dies. She goes through a divorce, but she used that money when she inherited it to pay a joint mortgage. Guess what? She just commingled that money. He's entitled to half of it. So if you don't want your daughter-in-law or son-in-law to take half when you leave, you need to structure things in a way to keep that from happening. Again, opportunists take advantage of the kids, or the kids get in trouble with the money because they don't know what they're doing. Number one concern for clients is their children's financial maturity. Again, I won't ask for a show of hands, but for those of you that have kids in the room, think about the fact if you dumped $500,000 on a child at one point in time, what would your child do? Spend it, right? Most of them will spend it. Most of us, our kids live paycheck to paycheck, right? So if you dump that amount of money at one time on somebody, maybe they'll do okay with it. But about 65% of them will not. The 18-18 rule. A lot of people will blow through their entire inheritance in 18 months or less. A scary thing to think about, right? So making sure that you're putting things in there to protect your loved ones. So going back to Bill and Mary, going back to Susan, I already told you she's looking at a divorce because this is Jason. This is her lazy husband. And she's been wanting to divorce him for a long time, and she really just hasn't had the money to do it. Now, all of a sudden, she inherited money, but she's been paying the mortgage with it. And his name's on the mortgage. Guess what? He's taking half. Then, of course, we go to John. As I say on here, John is a walking liability factory. He likes fast cars, gambling, women, everything that you could possibly think that's wrong with John is in fact true. All right? Mom and dad just left him $700,000. What do you think is going to happen? So he's going, right? He's going to gamble it, he's going to spend it, and his creditors are going to take a lot of it. Because John hadn't paid taxes in 10 years, so I got some problems. So this is a summary of a bad estate plan, right? There were absolutely no protections along the way. Bill and Mary did exactly what they thought they were supposed to do. They got advice from an attorney who didn't do this for a living, who was a good guy. Frank's a good guy. I don't take anything away from other attorneys. I don't play in their field either. I don't do family law. This is what I do. But it's why you have to talk to somebody that does this to make sure that your estate plan does what it's supposed to do. There has to be another alternative. At the end of the day, the alternatives are, number one, make sure you have your powers of attorney done. In South Carolina, we have two. We have both a financial and a healthcare power of attorney. You got to make sure that you have both in place. The other thing too is to make sure that your documents do what you want them to do. We talk a lot about trust. Trust can be used to keep things out of probate. Again, I know that I'm probably bumping up here on time, but a trust is not supposed to be a catch-all for everything. All right, there are people that don't need trust. But if you have real estate in particular, a trust is incredibly helpful to keep things out of the probate process. Know the difference between what a trust and a will does. A trust is almost like a bucket. It looks like a will. It says who you want to get things. But unlike a will, it exists the moment you create it. You put stuff in the bucket. You put your real estate in it, put accounts and such in it. And when you die, then nothing's in your name. So nothing goes through probate, and those assets are protected for any type of creditor, including some Medicaid estate recovery plans. You also can use trust, irrevocable trust for Medicaid planning. So if that's something you're concerned about, please talk to me. Ask me questions about that. I'm happy to walk through it. We talk about giving Bill and Mary a do-over. They put all their documents in place. Bill still has a stroke, but guess what? He's got his powers of attorney in place. Mary has all the authority to make decisions for Bill. Bill dies, but guess what? Everything's in the trust, so it doesn't go through probate. So again, it's protected. Not only that, but he's put things where he's leaving them to Mary in trust. Susan's the trustee. It's all there to take care of Mary, but because it's not in her name, she doesn't have to spend it down to $2,000. You can leave things to your spouse to take care of them without causing problems. There's no death probate. Again, same thing for Mary. She's taken care of. Will not have death probate there either. And then for the kids, they can set it up so that they can leave things to their kids 50-50 because they love their kids, but they can put stipulations on it where it's protected. I tell people your estate plan's like a tube of toothpaste. As soon as you squeeze it out and give it to everybody, all the protection is ended. But if you leave it to them, like for Susan, it can go into this trust for her where she's her own trustee. She can use it to pay the mortgage. She can do anything she wants to with it. But because it's not in her name, when she divorces Jason, he can't take half of it. Same thing for John. John can't be his own trustee because he makes very bad decisions, but it can go to him in a way that there's a trustee managing it who's doling it out to him. And because it's not in his name, his creditors cannot come and take those assets. So this is just really, really smart estate planning techniques that can work for all of us. I've already talked about that. Incentive trusts, these are where if you want to incentivize a certain behavior. So if you want, for example, in this one for John to not be on drugs anymore, okay? You can have $20,000 every year if you show us that every month you're going to get a drug test done and you're not testing positive. I mean, you can do anything like that that you want to incentivize a type of behavior. You get money for going to college, or you get money for holding a steady job. Of course, if you've got loved ones that have special needs, so if you've got a grandchild or another loved one that has any type of special needs, that's got to be dealt with in the plan. That's a different type of planning that needs to be done to protect them. Why I do what I do. So this is the last little part, you guys, and this is personal for me. I was telling somebody earlier when we were eating lunch, I didn't go to law school intending to do this type of law. I went to law school thinking I'd be a litigator because obviously, as you can tell, I like to talk, and I thought I'd be good at it. And I actually hated litigation, and so I started looking for something else to do. And I started realizing how many people needed to hear this, including my own family. So growing up, my parents cared for both sets of my grandparents in our house at different times. First, my dad's parents, and then they passed away. Then my mom's parents. My parents during that time period put 2 kids through private school. They worked jobs and cared for 4 loved ones. I don't know how they slept. I don't know how they did any of it, but I do know they went into over $65,000 in credit card debt, paying for stuff for their parents because their parents didn't have enough money. Everything from picking up prescriptions to paying for caregivers. My grandfather was wounded in World War II. He could have had benefits, but they didn't know. And nobody was there telling them, hey, this stuff is here. You can do this in a different way. And so being the blue collar kind of people they were, they just plugged through it. They just did it. And that's not the answer. So at the end of the day, when I meet with clients, what I'm really seeing is opportunities to say, hey, there's a different way to do this. We can try to protect what you've worked hard for, that there are benefits and programs out there that can help you and can help your loved ones. And your estate plan has to reflect that. So I'm passionate about what I do. I enjoy what I do. And hopefully you've learned something today. And, again, I'm happy to answer any questions that you guys have. I think there's a couple of slides on here about what kind of legacy will you leave your family. At the end of the day, that's what estate planning is. It's not just documents. We're not just caring about assets. All of this has to do with family relationships and debts and caregivers. All of it's tied together into what I would call legacy. What kind of legacy do you leave?